My name is Nick Gebelt. I'm a bankruptcy attorney here in Whittier, California, and I practice bankruptcy law throughout the Central District of California. I also do tax debt resolution. In a previous video, I gave you a three-part test for determining whether or not an income tax debt is dischargeable in bankruptcy. To summarize that test, the tax return has to have been due with extensions at least 3 years before the day you file your bankruptcy papers. Number 2, you must have filed a legitimate non-fraudulent tax return at least 2 years before you file the bankruptcy papers. And number 3, the tax that you're trying to discharge cannot have been assessed by the taxing authority, and we'll just generically use the IRS, though this does apply to other taxes. The tax cannot have been assessed by the taxing authority during the 240-day window immediately prior to the day you file your bankruptcy papers. And I said that the 2-year rule has created a funny patchwork of inconsistent law throughout the United States. A lot of it centers on what constitutes a tax return for bankruptcy purposes. Now you might think, well, I sent the return in, what's the big deal? Well, the Bankruptcy Code has a definition for what constitutes a return, and one of the requirements is it has to have been filed satisfying all the filing requirements. So, there are 3 main positions in this. In order to understand those 3 main positions, I need to give you a little vocabulary. Suppose you don't get around to filing the tax return, and after a while what's going to happen is the IRS is going to file a tax return on your behalf. Such a return is called a substitute for return, or an SFR. If you file a return after the IRS has filed its substitute for return, or its SFR, and you wait 2 years, is that good enough? Well, here are the positions around the country. The Fifth Circuit, which encompasses Texas and Louisiana and Mississippi, has a very harsh rule called the McCoy rule because it came up in a case where McCoy was the debtor. That rule says if you file the return even 1 day late, it is never considered a tax return for bankruptcy purposes. Interestingly enough, even the IRS doesn't go along with that rule. They say it's just unduly harsh. Another perspective comes from the Eighth Circuit, which encompasses some of the Midwestern states. The Eighth Circuit takes the position, as long as you file a return even if it's after an SFR, it's considered a return for bankruptcy purposes. And of course you still have to wait the 2 years and satisfy the 3-year and 240-day rules, but if you do in the Eighth Circuit, you're home free. The Sixth Circuit has taken a middle-of-the-road position. It says that if you file the return late, you're okay, but if you file the return after the IRS has filed the SFR, then you lose. Well, we live in the Ninth Circuit, and I practice, as I said, in the Central District of California, which is part of the Ninth Circuit. The Ninth Circuit Court of Appeals has never considered this question. There are a couple of lower courts that have considered the question, and they've come to diametrically opposed positions. In 2014, 2 of those courts handed down their decisions. The first came in the Northern District of California, and it was the United States District Court that interpreted the law following the Fifth Circuit's draconian position. And the U.S. District Court in the Northern District of California said, sorry, you're even 1 day late in filing the return, you lose. It doesn't matter whether there's an SFR or anything else. It's never never a return for bankruptcy purposes. Then the Eastern District of California handed down a decision also in 2014, and they followed the Eighth Circuit's position, and that was if it's a return filed after a substitute for return, that's okay, as long as it's a legitimate return and you wait the requisite 2 years. That decision is called the Martin decision, and it was appealed, and that went up to the Bankruptcy Appellate Panel for the Ninth Circuit, and the Bankruptcy Appellate Panel said that was the correct holding, and they sided with the Eighth Circuit. The tricky thing here is that the bankruptcy appellate panel's decisions are not binding on any bankruptcy judge other than the judge from whom the appeal was taken. However, the bankruptcy appellate panel's decisions are binding on the bankruptcy appellate panel. It's sometimes called the BAP, by the way, BAP. And so if you file an adversary proceeding in the bankruptcy court to try to get a determination of dischargeability, and you lose and you appeal to the BAP, well then the BAP is going to be bound by its Martin holding, and it will say, no, the debt is dischargeable. Ultimately, what's going to happen in the Ninth Circuit is the case is going to have to go up to the Ninth Circuit Court of Appeals, and because there is inconsistent law throughout the United States, and the U.S. Constitution says that one of Congress's enumerated powers is to develop uniform laws on the subject of bankruptcies, eventually the United States Supreme Court will have to consider the question. But as it stands now, we're in a somewhat no man's land in the Ninth Circuit Court of Appeals, and so you better find a good bankruptcy attorney if you'd like to challenge the IRS's position. In fact, I'm in the process of litigating this very question. And if you'd like to talk about this further, I can be reached at 562-777-9159.